Welcome, everyone. I'm so glad you're here. My name is Andrew Gothard. I'm the statewide president of United Faculty of Florida. For those who don't know or aren't members of UFF, we are the statewide higher education faculty union in the state of Florida. We are part of the Florida Education Association, and we represent the bargaining interests of over 25,000 higher education faculty and graduate students at all 12 public state universities, 16 state colleges. We also have 4 graduate assistant chapters, 4 K-12 lab schools, and a retired chapter that covers anyone in higher ed who has retired but wants to continue to be a part of the union movement that UFF has built, and we are continuing to develop and deploy across the state every day. So thank you again for being here. I want to go through and introduce all of our panelists who are going to be speaking and presenting today. So this is not in any particular order. So the people I introduce first are not the most special, and the people at the end are the least special. So first off, we have Cami Axeus, who is a labor relations specialist for the United Faculty of Florida. With over 12 years of professional experience in the labor movement, she has served in various roles and worked for national as well as local unions, such as the American Federation of Teachers, the Service Employees International Union, or the SEIU, the Broward Teachers Union, and the United Federation of Teachers. Cami is passionate about fighting for social justice and building the labor movement. So also we have Emily McCann, who is also a labor relations specialist assigned to the United Faculty of Florida's chapters in Northern Florida. She has worked for unions at the national, state, and local levels, including AAUP, or the American Association of University Professors, the Florida Education Association, and now the United Faculty of Florida. She is a proud product of public schools from her elementary to her doctorate. We also have Morenike Fajana, an assistant counsel at the NAACP Legal Defense Fund. Most recently, she's litigated criminal justice and voting rights cases in Florida, including challenges to HB7 and SB90. And before that, she has engaged in extensive civil and human rights work across the US, Haiti, and Europe. We also have Jerry Edwards, who is a staff attorney at the ACLU of Florida. He is a Florida native and 2017 graduate of the University of Florida Levin College of Law. And he spent his first few years in practice working for federal judges in Texas and Kentucky. Jerry then worked as Assistant Solicitor General for the Attorney General of Kansas. And in July of 2021, Jerry returned to Florida and joined the ACLU of Florida as a staff attorney, focusing his practice on criminal justice and free speech issues. We're also joined by Emerson Sykes, who is a senior staff attorney with the ACLU Speech, Privacy, and Technology Project, where he focuses on First Amendment free speech protections. Prior to joining the ACLU, he was a legal advisor for Africa at the International Center for Not-for-Profit Law, Assistant General Counsel to the New York City Council, and a Senior Policy Fellow in the Office of a Member of Parliament in Ghana. Emerson is a graduate of the New York University School of Law, the Princeton School of Public and International Affairs, and Stanford University. And last but not least, we have Connor Flynn, who is a senior litigation attorney at Donnelly and Gross in Gainesville. Connor is a trial lawyer, and he argues cases to juries, judges, and arbitrators. He regularly advises faculty in employment matters and frequently represents the public sector in litigation, including the ongoing academic freedom litigation, where the University of Florida professors won a preliminary injunction in federal court against the University of Florida's conflict of interest policies. So we are not only thrilled, but we are honored to have all of these people with us today to help us talk about HB7, academic freedom, and how we can still teach the truth, and we can still support our students, we can still support higher ed in Florida, in spite of these really terrible laws that are coming down out of Tallahassee, it seems like every day. So we're going to move through this presentation in a pretty orderly fashion, and we're going to start with a presentation on the legal rights of faculty and students in the classroom, and this is going to come from both the ACLU and the NAACP. Jerry, who's going to be starting us off for your group?
Morenike will be starting us off.
Okay.
Thank you. And if we could just go to the next slide, please. Okay, so I'm going to kick us off just by kind of doing some table setting and talking about how we got here. Part of the reason that we're here and the reason for so many of the laws that we're seeing across the country that restrict classroom discussions on topics like race and sex and equity are coming as a result of pushback to the 2020 racial reckoning after the murder of George Floyd. And the response from all facets of society, particularly in education, to try and address that racial inequality. So former President Trump's executive order 13950 on combating race and sex stereotyping kind of marks a turning point for this backlash to the racial reckoning. I think it's really the first time that we saw on a large scale a government trying to restrict discussions and speech on topics such as race, sex, and inequality. Many of you are likely familiar with this executive order and the fact that it prohibited government contractors from using a set of ideas, which the order defined as divisive concepts in diversity, equity, and inclusion trainings. And although this executive order itself was short-lived, not only because it was enjoined by a federal court within months, but also because there was an election in 2020 and the new administration rescinded it immediately on the first day of office. The impact of this order is really very wide-ranging because it set the stage for what was to come. And what has happened over the last two legislative cycles, so 2021 and 2022, is that more than 30 states have proposed what we like to call anti-truth bills. And these are bills that are trying to limit truthful, accurate, fulsome education, whether at the K-12 level, higher ed, or both. And the main thing that the majority of these bills have in common is that they adopt the divisive concepts that are defined in former President Trump's executive order, and they restrict how educators can use those concepts in either, classroom discussion, classroom instruction, or training that happens outside of the classroom. So far, 12 states have actually passed these laws, and obviously Florida is one of them, and that's the reason why we're here. I also wanted to just highlight a few other states, Oklahoma, New Hampshire, and Tennessee, because there's active litigation ongoing there. The ACLU is litigating in Oklahoma and New Hampshire specifically on behalf of educators, alleging that their divisive concepts bills restrict the First Amendment rights of educators there. So I wanted to just let folks know that in case they were not familiar, and you can find more information about those cases on ACLU's website. So leading, after the last legislative session in Florida, we have HB7, which sometimes is called the Stop Woke Act, sometimes it's called the Individual Freedom Act, that was passed by the legislature in April of 2022, and which was a signature policy initiative from Governor DeSantis, and which went into effect as of July 1st, 2022. It follows this exact same model of incorporating the divisive concepts from the Trump executive order and restricting how both K-12 and higher ed educators can use those concepts. I won't go into more detail about what HB7 does right now because that's going to be covered later on in the presentation. I just wanted to share a little bit of context for how we got here. And I will now pass it on to Connor.
Hello, everyone. Right now I'll back up in terms of that table setting. A lot of this is interconnected in terms of some of the voting rights legislation that we've seen going on and how that kind of the slippery slope into the academic freedom scenario. There was a lawsuit, and there is currently an ongoing lawsuit. Started out with some of the voting legislation that was coming out of the Florida legislature, and that the plaintiffs who sought to expand access to those voting rights were effectively prevented from providing that expert testimony by the University of Florida. We tried to work it out with the University of Florida. We tried to explain, hey, you can't quite do this. The University of Florida was quite clear in its position that, yes, we certainly can. And then at the beginning of this past November, the story hit the New York Times, blew up, and the university abruptly shifted its outward position a number of different times. But now we are in federal court. There was a hearing for a preliminary injunction against the University of Florida for its conflict of interest policies related specifically to outside activities. Under the UFolio system, you may have something similar at UF if you're watching, or at your home institution, where someone's asked to declare if you're doing something, the school wants to run it by first to see if it's adverse to the interests of the institution. Well, these professors who were hired as experts to provide testimony in support of plaintiffs alleging that these voting restrictions were unconstitutional, the University of Florida wanted to stop that because it would have been adverse to the interests of the state. Well, professors are not serving at the pleasure of the governor. They are speaking on their expertise in their personal capacities. Thankfully, Judge Walker in the Northern District of Florida has issued a preliminary injunction. So for the time being, there is a federal stop on UF's current iteration of the policy. At most recent glance, we are looking at a March trial date for this to move ahead to trial. In the meantime, the University of Florida and their counsel have appealed, and they're going to be headed to the 11th Circuit. And so court watchers who are familiar with the 11th Circuit have a little bit of curiosity to see if they're going to kick it up to our new composition of the Supreme Court. But March is our timeline right now. And that's the current state of the UF academic litigation. So you'll see here as well, a number of the protections that you're going to enjoy at your home institution. You are going to have these First Amendment rights, and there's going to be more discussion following this where they stem from. And I believe that I am going to be handing this off to Jerry.
It'll be Emerson.
Emerson is next. My apologies.
Thanks very much. Can you, this is sort of an overview of the different, oops. Sorry, I can turn my camera on if I can find my cursor. Sorry, you would have thought by now we could have figured out Zoom, but indeed we have not. So this is an overview of the different sources of potential protections for academics. Your annual contracts, the university policies and regulations, the faculty constitution. There are all whistleblower protections. There are all sorts of different sources of protection that are sort of, unique to your particular position or unique to your particular institution. But I'm a First Amendment attorney with the ACLU's national office. So I wanted to take a few minutes just to talk about the sort of bigger ideas around the First Amendment, academic freedom, and free speech. So if we can go to the next slide, we're going to go through the slides quite quickly. Just as an example, I know not all of you are at UF, but there are a variety of regulations at each university that are potentially relevant. So I encourage you to sort of click around your university's website to figure out what are the different policies that might impact, your ability to teach free from censorship and discrimination. So there may be directly an academic freedom regulation. There may be some non-discrimination policies. There certainly are non-discrimination policies, tenure and promotion, as well as avenues for filing complaints against faculty. Next slide, please. And this is just an example of a statement from a university. It says, consistent with the exercise of academic responsibility, a teacher must have freedom in the classroom in discussing academic subjects, selecting instructional materials, and determining grades. The university student must likewise have the opportunity to study a full spectrum of ideas, opinions, and beliefs, so that the student may acquire maturity for analysis and judgment. So I would wager that almost every university has some kind of very strong, highfalutin statement like this somewhere on their website. Of course, where the rubber hits the road is a much trickier question, and we'll get there. So can we go to the next slide? So as I said, there are multiple sources of potential regulation at different levels. There's the federal constitution, which is my specialty. Then there's the Florida Constitution, which I know almost nothing about. And then there's Florida state law HB7, which we have been studying quite closely. And my colleague, Jerry Edwards at the ACLU of Florida will talk a bit more about. But just keeping in mind that there are different sort of sources of authority that we're thinking through. So keep going, please. So here are just a few, as I said, there's a lot of highfalutin language around academic freedom and the protections of academic freedom in courts, including the Supreme Court. And one might even guess this Supreme Court might have some particular appetite for trying to protect academic freedom. So I just cut and pasted a couple of quotes that are sort of bedrock to our understanding of academic freedom, just to show the kind of lofty ideals that the Supreme Court at least claims to uphold in relation to this. So in one of the most famous quotes, it says, "Our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us, and not merely to the teachers concerned. That freedom is therefore a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom." So, you know, there are other quotes, I won't go through each of them, but there's a lot of there's a deep well of quotes from the Supreme Court talking about the importance of academic freedom, not just for professors, not just for students, but for indeed the health of our democracy. As you see in the last one, it says, you know, if we don't respect academic freedom, at the very end of Sweezy v. State of New Hampshire, it says, "Otherwise our civilization will stagnate and die." So, you know, they're not mincing words about the importance of academic freedom. But, next slide. Academic freedom, I joke and say it's kind of a vibe, because there's all this strong language about why it's so important. But we also sometimes call it the cotton candy doctrine, because once you start really trying to chew it, it kind of disintegrates in your mouth. Because courts have also, as much as they've said these enormously lofty things about academic freedom, have also disagreed about what it actually is and whether academic freedom is on its own First Amendment right. So one question is freedom on behalf of whom and against whom? There's institutional freedom. So many cases are about, you know, whether the state or the executive branch can interfere with the operation of a university. So university discipline, university curriculum setting, all sorts of different ways that different kinds of government officials have tried to interfere with academic institutions. And so in many cases, courts have said academic freedom protects the university from interference from other government bodies. But what we also think about, and you know, there are places in the United States, not in the 11th Circuit, but there are circuits that have said academic freedom actually only protects institutions. It isn't an individual right. It's a right of academic institutions vis-a-vis other government agencies. But we think a much more fulsome and accurate view of the academic freedom includes faculty speech. This includes, when I say faculty, I don't just mean tenured faculty. I'm also, you know, referring to others who provide instruction and participate in the intellectual life of the university. And here there are several questions, and we'll get in a little bit to the details. But one question is, was the faculty speech on a matter of public interest, in which case it has special protections. And then another calculation or another, you know, point of the analysis is whether the speech took place inside or outside of a class, as a part of an extramural, was it a part of a required course? All of these sort of detailed factual situations can affect how a court views whether or not speech by an instructor is protected or not. So you can imagine, you know, speech on the topic of your expertise within your class has very robust protections, right? Like that's very much within the sphere of your discretion as an instructor to teach what you want to teach inside your class. And, you know, what you say in your personal capacity is also very much within your First Amendment rights. But there are some ways in which the university can restrict your speech or regulate speech. So we'll get into those in a second. The last one is for students. And I, believe strongly that students do have a stake in academic freedom. I think, if we really look at how, I don't need to tell you, but if we look at how universities work, the line between teacher, student, employee, staff, researcher, these are all very blurry, and many people wear many hats and sometimes at the same time. You could be a graduate student who's also teaching a course, who also has a campus job, who's also consulting for, some state body at some point. So you can really, I think the idea that students don't have academic freedom sort of ignores, one, the contribution that they make to the academic life of the university, but also how people are students and teachers and and employees all at the same time. But I will say that courts have been I've been a bit more hesitant to recognize sort of independent academic freedom rights on behalf of students. But, my personal opinion is that that shouldn't be the case. Should we go to the next slide, please? So what is covered? We talked about this a little bit already, and I'll try to go quickly through this. I don't want to take too much time, but as we said, it's for full-time, part-time, tenure track. All sorts of folks are protected by academic freedom. It includes the liberty to conduct research and draw conclusions rooted in evidence. That's what I was talking about in terms of sort of your own use of your intellectual and scholarly powers is firmly within the context of academic freedom, including selecting course materials, pedagogy, how you structure your lesson plans, as long as it's germane to the subject matter. So again, there can be certain limits. So, the university might discipline you if you're just discussing Mark Twain in your physics class, right? So if you're not keeping on topic, or if you are, just being mean to certain students, targeting certain students, grading them poorly, being unfair to them, that does not necessarily fall within the protections of academic freedom. There are all sorts of ways that the school can make sure that you're doing your job in a responsible and professional way that do not get into the viewpoints or your expertise or your particular analysis. Next slide. So here are just a couple of examples that we pulled. We can go through them quite quickly. We don't need to linger, but basically there was an African-American student who alleged that a professor used offensive language in a lecture. And then that professor was not offered a class for the following semester, and the court ruled in favor of the professor, saying that the topic at hand, race, gender, and power conflicts in our society, was a matter of public concern, and the teacher's in-class speech deserves constitutional protection. So of course, I'm an unabashed progressive, but if we want to make sure that you have academic freedom, that means that you have the academic freedom to say things that I like, as well as things that I might not like. So it is important to acknowledge the sort of two sides of this coin. And unfortunately, I'll say, a lot of the press is around sort of professors' right to be obnoxious and offensive. But we're also talking about professors' rights to determine what is the best thing to teach at any given time. So next slide, please. The next one is about a female student who filed a sexual harassment complaint against a teacher for repeatedly using lewd and graphic language in their English class. And here, the teacher's use of vulgar language was not germane to the subject matter, and therefore was unprotected. So again, you have academic freedom over your ideas and your expertise, but that doesn't mean you really get to say whatever you want, especially if you're targeting, harassing, discriminating, being unfair to students in any of those ways. Next slide. HB7 deals more with curricular speech, so we want to talk a little bit about curricular assignments. There's a couple of cases. One was where the Quran was assigned, and a lawsuit alleged that this violated the separation of church and state. And the court found that there was obviously a secular purpose to assigning it, and therefore academic freedom protected the right to assign a religious text in the context of scholarly inquiry. Next slide, please. And I think this is our last example. this was a college theater student who didn't want to recite a particular line because of her religious beliefs. And the school, and she left the program because they said that she would not be able to change the scripts for future assignments. And, you know, the court found that the school could compel her to, you know, speak the lines of the play because it was reasonably related to a legitimate pedagogical concern, right? That the idea is that it's reasonable for a school to say you don't get to write your own scripts when you're performing a play. Next slide, please. Okay, so I'll wrap up there. Please do reach out if you have any questions. And sorry, we don't have hours and hours and hours to dig into the nuances of all of this, but I'll turn it over to Jerry Edwards.
Thank you, Emerson. So I'll jump in here. Emerson gave a great presentation on the First Amendment. I will just touch on how HB7 is currently being challenged. There are two cases in Tallahassee right now in the federal district court. Both are before Judge Walker. That's good news because Judge Walker is a very fair judge, at least in my estimation. And if there are any further cases filed in the southern or northern district of Florida in Tallahassee, they will also go before Judge Walker as related cases, as long as they're challenging HB7. In Falls, there is one higher education plaintiff. That's Professor Robert Casanello, who's a history teacher at UCF. Thus far, the judge denied the motion for preliminary injunction as to the K-12 and the employer plaintiffs. He has not ruled on Professor Casanello's claims. There's a question of whether they suit the right parties, and that's kind of a tricky issue here in the 11th Circuit. For those who are unaware, the 11th Circuit is the federal appellate court, and it covers Florida, Georgia, and Alabama. So all federal district courts in Florida have to follow the 11th Circuit law. Preliminary injunction, because I know I'm speaking legalese here, basically what that means is that the defendants can't enforce the law during the case. So while the case lasts, and if the plaintiffs win at the end, a permanent injunction, the defendants cannot enforce law moving forward. So Falls is still happening. It's still in progress. The employer plaintiff is out. The judge dismissed her because there wasn't enough evidence that she's been harmed, but the education aspects are moving forward right now. With Honey Fund, this is purely an employer case, so it doesn't touch on education. The preliminary injunction hearing is occurring on August 8th. So we'll see how that pans out. That'll give us some more insight on what Judge Walker's thinking. But right now, the key takeaway is for higher education instructors like yourselves, we're still waiting to see how Judge Walker will rule on Professor Casanello's claim. Next slide, please. And so how we're approaching HB7 at the ACLU of Florida, and NAACP Legal Defense Fund is we're investigating it right now. We're developing our facts. What we really want to make sure is that if we do file a lawsuit, that it's a strong lawsuit, we have enough evidence, and we sue the right people so that we will get the injunction we're seeking. In other words, that the judge will tell the state to stop enforcing this law, at least as to the prohibited concepts. Right now, we're presently evaluating our litigation options. I can say that we do believe this law is unconstitutional, and so we are aggressively evaluating our litigation options. If you feel that this law will impact the courses you teach, feel free to reach out to me. My email is on the slideshow presentation here. I can also drop it in the chat. We're particularly interested in speaking with community college professors, untenured faculty, professors of color, gender and women's studies professors, then professors whose courses touch upon critical race theory, anti-racism, and or racial justice or social justice movements. So yeah, just feel free to reach out to us. Our conversations will remain confidential, and I'll make sure we get you in touch with the right person. Next slide, please. So contact information, again, I'll put my email in the chat. We appreciate it, and we'll hand it off to our friends at UFF.
Thank you so much for that thorough presentation on academic freedom and the way it applies in the classroom. Now we're going to shift to our service unit directors with the United Faculty of Florida. As you may know, we have put out member guidance on how to navigate HB7 in the classroom. So our service unit directors are going to talk about how that works and sort of walk us through the details of it before we move to the final portion of the presentation. So Emily, take it away.
Sure, just a sec. Let me get the screen shared. Okay. Just a sec. Here we go. Okay, share. All right, you guys should be able to see my presentation. Is that okay? Are we good?
You need to share it one more time.
Okay. All right. Are we good?
There you go.
Good. All right, so we're very happy. My colleague Cami Exeus and I will be presenting on House Bill 7's classroom guidance put together by United Faculty of Florida. We'll say this at various points in our presentation, but UFF's protections and ability to represent you will be determined upon your membership status. So in terms of our discussion of how and when we can advocate and represent you, it's for members. But all faculty who are part of unionized campuses across Florida are welcome to, that are under UFF are welcome to join. So without further ado, here we go. So want to also do some table setting of our own, to borrow our colleague's term. There is a very specific legislative and political context for these bills that, in addition to the racial and context that was brought up earlier. Taken together, recent legislation demonstrates a swing towards extremist legislative control over university management, threatening academic freedom. You see this in House Bill 233's Intellectual Viewpoint and Diversity Bill, House Bill 7044's, or the bill that, or Senate Bill 7044, the bill that includes post-tenure review and forced arbitrary changes in accreditation agencies. And finally, House Bill 7, amount to attacks on academic freedom and aimed at intimidating faculty into self-censorship. Unlike the while the provision currently against, the prohibitions against certain topics or espousing certain positions currently intervenes in the culture wars, academic freedom is an essential part of a free, generally democratic society that depends upon rigorous open debate to make progress. Today, it's anti-woke. Tomorrow, it could be attempts to muzzle climate change research or to research on the impacts of pollution to surrounding farming communities. Through these bills, the legislature is attempting an honestly insidious power grab aimed at concentrating increasing amounts of surveillance and power over state university system institutions and colleges, and in taking it away from locally appointed and local boards of trustees and investing it more increasingly in the hands of governor appointees. Be it through attempts to pit students against faculty, faculty against administrators, or through the viewpoint diversity surveys, or faculty against their own tolerance for ambiguity and risk, anticipated self-censorship from faculty is a feature and not a bug of these bills. So, some questions. How does the bill literally work? As far as higher ed is concerned, the bill has three major points. There are prohibitions against espousing, or frankly, any other synonym that the legislature could come up with for indoctrinating on taking a position on various prohibited topics. The enforcement mechanism is that there's a threat of a loss of performance funding for institutions that fail to adequately investigate and punish substantiated findings. And that's a pretty significant cudgel. Finally, the Board of Governors recently developed rules that implement House Bill 7's requirements. That regulation is contained on the slide. Institutions are required to adopt guidelines for reporting, investigating credible allegations. That's usually done in-house from everything we've seen so far. Substantiated allegations will be reported to the BOG by the university, and punishment will be determined locally. It's only in these rules, it's only failure to comply with the directive once finding is found may result in termination. Put differently, the regulations seem to contemplate that faculty might not be terminated instantly. It's only once they've been advised that whatever they're doing is not in compliance with the law that they could be terminated or may be terminated. So the upshot of this is that it is UFF's position that collective bargaining agreements provisions for just cause and discipline are not superseded, that any discipline that a university would attempt to mete out to a faculty member would be subject to the grievance procedure and would be eligible for United Faculty of Florida representation. And that's a big deal. So big question, what do House Bill 7, what activities does House Bill 7 cover? House Bill 7 amends Florida Statute 1005.05 to read, and I won't read it to you, but it's the relevant thing here is it shall constitute discrimination on the basis of race, color, national origin, or sex under this section to subject any student or employee to training or instruction that espouses, promotes, advances, inculcates, or compels such student or employee to believe any of the following. So what do training and instruction mean? Well, for our purposes, the Board of Governors has already defined it on the text on this slide. Training is defined as a planned and organized activity conducted by the university as a mandatory condition of employment, enrollment, or participation. Instruction is defined as the process of teaching or engaging students with content about a particular subject by a university employee or person authorized to provide instruction by the university within a course. So let's try out a range of university topics that might apply here. And this is just UFF's position, but advising work would not be covered. DEI trainings would be covered if they are mandatory, but I think we can find some ground here that they're not covered if they're not mandatory. DEI work in general, if it's neither training nor instruction, fine. And sorry, DEI, diversity, equity, and inclusion. As far as instruction is concerned, that's covered. Research, not covered. Brown bag talks on campus, not covered. So this is an evolving body of understanding. The law just happened, so we may find that this shifts a little as it moves forward, but this is our best guess right now. So in light of that uncertainty and respect for how much we don't know right now, UFF's guidance is presented as a framework based on lower risk, moderate risk, and highest risk actions. There's a lot we don't know, as I said. And so we want to empower you as faculty and staff to make the best possible choice for yourself based on your tolerance for risk, your vulnerability as a faculty member, or your sense of your vulnerability as a faculty member, and how strongly you feel about academic freedom. Although we hope if you're here today, you feel just as strongly about it as we do. So before we get started, good ideas for everybody involved. Fuller text of this syllabus disclaimer is included on House Bill 7's, or UFF's House Bill 7 guidance document, which can be found on our website, and I believe has been shared in the chat. But in general, it is a good idea in this case, and in general, to have this disclaimer. No lesson is intended to espouse, promote, advance, inculcate, or compel a particular feeling, perception, viewpoint, or belief. And there are lots of good reasons for doing it, if only to show to underline the fact that your work that you're engaging in as an instructor is about critical inquiry, about the free and fair discussion of ideas in your classroom. Recording lectures. So this may be good for some people, not for everybody, but recording lectures is something that United Faculty of Florida recommends, especially for faculty considering the medium and high risk options. Making recordings of your lectures as you give them would provide a record that will indicate whether or not you were truly in or out of compliance with House Bill 7. Now, the problem with having that record is that if you weren't in compliance, you will have evidence of that. There are some things to know about the pitfalls, potentially, of recording your lectures. You should and must retain it, arguably as a public record. Whether or not it would be subject to FERPA exemptions would be very fact specific. So for if you're worried about that, you should consult with your labor relations specialist. You are also, if the administration asks for a copy of any lectures that you have, required to hand that over to them. However, it can be invaluable proof, especially since after House Bill 233, students are empowered to record lectures without not informing faculty ahead of time. So this might be a very important record as a sort of counterpoint to whatever students may invent. It's a good practice. We think that this would be an important record for you to have. So first of the low risk actions. Don't teach or address any of the topics prohibited in House Bill 7. Don't remove all posters and art in your office that endorse positions prohibited by House Bill 7. Don't speak about any of the topics addressed in House Bill 7 with any student groups you may sponsor. Don't guest lecture on any Florida campus about any of the topics addressed in House Bill 7. Admittedly, this is an extreme course of action, but faculty looking to have as little risk as humanly possible will be well served to follow these. That we don't know how vigorously universities will enforce this or how creative the Board of Governors will be in reviewing whatever investigatory findings universities have. So if you are understandably terrified, this is the course of action we suggest. However, there's the medium risk option, which we think is a compromise between some risk and enjoying the fullest exercise of academic freedom as we think you can get away with without risk of repercussion or censorship under the current law. One thing we actually struck, basically what you need to know is in House Bill 7 classroom guidance, we have answered and offered a way to rephrase or reframe your instruction on each of the given topics that are prohibited. We won't go through that line by line because that will be tedious. But if you want to see the detailed information, you can see it on the House Bill 7 guidance. What you do need to know is that the prohibitions rely on cartoonish representations of what happens in higher education classrooms. Several of them will be pretty easy to avoid. You probably will never have said some of them in your classroom ever. That being said, what we've noticed in general, or what we can generalize about all the prohibitions, is that faculty who can carefully parse in their lectures and materials the difference between inherent virtues and qualities of ideas or people versus the empirical effects on certain practices on groups of people should be fine. So there's a way to thread the needle and frame your discussion such that you can get away with it. When in doubt, our advice is to focus on the research and focus of the effects of certain policies impacts, for example, on different groups of people or different policy outcomes. Keep it empirical, keep it about the research, and invite students to present their own sort of research and engage with the ideas themselves. We believe that should keep many of you safe. Here's a higher risk option. Change nothing. Teach as you would teach. One of the upshots of this is that you might want to serve as a test case for potential litigation, which our partners at the ACLU of Florida and NAACP Legal Defense Fund have talked about today. And you may want to seek that and talk to them about that already. Note, members under investigation for violations of House Bill 7 should contact their chapter leadership and assigned UFF Labor Relations Specialist ASIM. There's a lot about the investigation process, including timelines. We don't know yet. So the sooner you give us a heads up that we need to represent you, the better we'll be. We don't know what the outcome of this litigation will be, and we don't know what the outcome of representing you is. But there are some values that some faculty may feel are worth defending, or you may feel that you're at a point in your career that you want to take this risk. If so, UFF stands with you. My colleague Cami Exeus will describe what our representation will be for members who take this risk in the next slide. But know that it's a risk, but it is a supported risk. Mm-hmm. However, I do want to say that as your labor relations specialist, we can't encourage you to not comply with the law, nor would we wish that you would understand us to do so. We are merely, again, holding out options for you that will help you decide how to approach this next fall semester. So I'm going to turn this over to my colleague, Cami Exeus.
Thank you, Emily. Good afternoon, everyone. We certainly hope that it will not be the case for any one of you listening here. However, if you find yourself in a situation where you are being investigated and or disciplinary action is being taken against you for alleged HB violations, Our affiliates, FEA, AFT, and NEA provide UFF members with protection from personal financial liability stemming from employment-related lawsuits. I would like to emphasize that our Educators Employment Liability Program covers only UFF members. We will be there working together to ensure that your collective bargaining and constitutional rights are protected as you navigate what can be an incredibly stressful situation. Although we can assure you that we will be there fighting with you if you are falsely accused of HB7 violations, we know that this is not an effective long-term solution to the attacks on your academic freedom. The recent attacks on academic freedom is a political problem that requires a political solution. And the most direct and effective solution is GOTV, get out the vote. If we do not get out the vote and ensure that we elect leaders in legislatures who support higher education and believe in your right to teach freely, we all know what's going to happen next year. We'll probably be hosting another one of those webinars discussing yet another bill that has infringed on your academic freedom or tenure. And you're yet again learning to navigate how best to educate your students in an increasingly hostile environment and worrying about your job security. It should not be like this. We have the ability to change the political landscape this coming election in favor of public higher education. The UFS is organizing its largest get out to vote effort in its history. We believe in supporting pro-public education candidates up and down the ballot. Therefore, we are asking all of you here today to join us in our effort to get out the vote. So please visit our website. It's going to be posted on the chat to learn more about this campaign and how you can get involved. So yes, we have mechanism in place. We have protection for UFF members. But like I said, this is a situation where we need to get out and vote and make sure that we change the political landscape. That's how we solve this problem. Thank you.
Thank you, Cami and Emily. So with our last few minutes, I just want to emphasize a few things. And I think it builds upon everything that our friends and colleagues here in the ACLU, the NAACP have been presenting, what our service unit directors have been talking about now. And that is this: we're not going to get change in Florida unless we make change. And there are a lot of people in this world and in this state and in this country who look around and they complain about what's going on, and they complain about losing their rights, and they complain about just the state of the society in which we live, but they don't do anything. And let me tell you something, at the United Faculty of Florida, we are doing things. We are fighting, we are on the front lines, and we are dedicated to making sure that every higher education faculty member can give the best quality education to their students, which is absolutely central to the public good. It's central to the continued success of our state, and it's central to creating a well-educated and balanced and useful and good populace. It is central to what it means to be a citizen, not only of this state, but of the country and of the world. We are committed to supporting those rights, and we are committed to making sure that students have access to the best quality education that is available to them, that they have the right to hear about history that talks about them, to see people in historical context who look like them, and to learn about whatever interests them, and to take that knowledge and to build a better world out of it. And I can commit this, that as long as I'm the president of United Faculty of Florida, we will continue to fight for these rights. And Cami is absolutely right when she says that the solution to this is, even though the ACLU is doing a fantastic job in getting a legal case off the ground, and I encourage you to reach out to Jerry and speak to him if you are feeling that this law is infringing upon your professional and personal and constitutional rights in the classroom. But courtrooms are not going to save us. Grievances on campus are not going to save us. This is a political problem with a political solution. And we have a leadership in Florida right now that is committed to infringing upon the First Amendment rights, the freedom of speech, the academic freedom of the entire higher education community. And the only way we are going to change that is by electing pro-higher education candidates and electing people who remember what it means to be an American. The United Faculty of Florida is committed to seeing that happen. And we hope that you are committed to seeing that happen too. So if you're here today and you're not a member of UFF, we encourage you to join. If you're here today and you're tired of having things done to you by your government and you're ready to take back control at the ballot box, join the United Faculty of Florida. If you're tired of an administration that clings to the wills of Tallahassee instead of defending the rights of students and faculty on your campus, join the United Faculty of Florida. That's what's going to make the difference that you want to see when we join arm in arm and we remember that solidarity means something and collective action gets shit done. Thank you, everyone. I'm really glad you were all here today. Again, we have contact info for Jerry Edwards and the ACLU in the chat. Please reach out to your local chapter leaders. If you're looking to join, click on the links in the chat for checking out membership, review the HB7 guidance that's available, talk to your local chapter leaders and your statewide leaders about how we can represent you and we can continue to fight for what is good and what is right in the state of Florida. And we'll be posting this recording after the event, so feel free to share it with your colleagues around the state, and let's build a movement that gets things done. Thank you, everyone. Have a great afternoon.